Hi everyone, welcome to Community College, brought to you by Conroy Law. My name is Evan Conroy, an attorney with Conroy Law. Today's goal is to provide a brief introduction to Indiana HOA and Condominium Association collections. You might be asking, why do we need to try to collect dues from people that are not paying them? Well, there's multiple reasons. First, assessments are what's used to pay for all the expenses incurred by the association, from repairing and maintaining common property, such as entrance signs, paying for landscaping, paying for insurance premiums, reserve funds. All these expenses are provided by assessments. If one owner does not pay their fair share, then other owners need to make up the difference. That isn't fair to the other due-paying owners within the community. Second, the board has a duty to enforce the community association's covenants. One of those covenants is going to be the obligation to pay assessments. Third, if the other members of a community believe that there is no consequence for not paying dues, or they believe many other people aren't paying their fair share, then those due-paying owners may become delinquent owners, right? They might make that transition where they choose not to pay their assessments. So you want to avoid that for sure. Now let's go over some common misconceptions about the collections process. One misconception is that the board loses control over the collections process. That should not be the case. Boards should be as involved as they want to be in making final decisions, right? One helpful compromise between wanting to stay involved and not having to deal with the sort of day-to-day affairs of the collection matter is to provide a debt collector, whether it's a law firm or a debt collection company, with some settlement authority. Things like giving them the payment plan links or letting the debt collector know what things can be waived, if anything, such as late fees or interest. Those sorts of things help empower the association to have a voice when interacting with the debt collection company. Another misconception is the time it takes to collect dues. Sometimes all it takes is a demand letter, right? You send the demand letter, they pay their bill. Other times owners need to be served with a lawsuit or receive a notice of a court hearing or some other sort of not so gentle nudge that this matter is moving forward and they need to come forward to try to work out a deal. Still, other owners will refuse to even pay even after a judgment's awarded against them. When that happens, typically you need to do post-judgment collections, whether that's scheduling a foreclosure sale or doing garnishment proceedings. It might take more time. Consequently, there really isn't a one-size-fits-all time frame for when a matter will get resolved in collections. Now let's talk about the power to assess and what can be collected. Community associations are subject to lots of types of authority, including state and federal law, documents recorded in the land records, and this includes things like restrictive covenants and easements, corporate documents such as bylaws and articles of incorporation, and finally, a community's own rules and schedules. That being said, a lot of what can be collected depends on the language in a specific type of document called various things, but typically the Declaration of Covenants. It's also called the Declaration, the CC&Rs, the CCRs, the Covenants. What makes it different from other community association documents is this one's recorded in the land records and it contains those restrictions, conditions, and covenants which everyone has to abide by that's subject to those documents. And typically when you talk about assessments and those rights and obligations pertaining to the obligation to pay assessments, you'll find that in the Declaration of Covenants. Other than assessments that fund the common expenses, there are often other types of charges that can be collected. For example, most, if not nearly all, Declaration of Covenants allow for the collection of cost of collections. This includes things like attorney's fees. This makes sense as an association should be able to make the delinquent owner responsible for those costs that are incurred due to their behavior. And so therefore, generally speaking, double check your governing documents, an association can seek to collect the unpaid assessments and related charges. One type of charge that has caused confusion in Indiana are the fines. There had previously been a long-standing Indiana court decision going back to the 1980s that called into question whether community associations could impose fines. However, new changes in Indiana law that will take effect this summer expressly permit associations to impose fines. Now, of course, the right to do so is subject to very specific requirements. Please feel free to check out our video on fines to learn more about those sorts of requirements for imposing fines. Finally, let's talk about late charges and interest. Indiana court decisions indicate that, assuming it's permitted in the association's governing documents, a community can seek to collect late charges and interest. It's important to keep in mind, though, that the amount of those types of charges cannot be viewed by the court as being a disproportionate penalty. That's legal jargon, has specific meaning in the case law, but essentially, if it's an outrageous amount, a court's not going to be willing to award it. So if you have questions about whether or not the amounts you're seeking are collectible, there's late charges and interest, ask your attorney. Let's now go over the types of procedures and documents that you can do to set up your community for success when it comes to collections work. First, make sure what you are seeking is permitted in your community's governing documents. Second, make sure you are complying with the proper budget approval process, as the budget will dictate the amount of the assessments. Third, make sure you are keeping accurate ledgers listing the individual charges being assessed and the payments being received. Fourth, have a collections policy in place for things like how many notices that will be sent out to an owner that's delinquent, things like just making sure that everyone is treated the same that's in a similar situation when it comes to delinquencies. And this should carry over when the matter's transferred over to a debt collection company or a law firm, making sure that you comply with those steps. This is especially important if you're seeking fines. You need to make sure that you have the proper fine schedule and you're complying with it when moving forward through the collection process. Finally, let's briefly talk about the various stages of the collection process. First, you have the pre-litigation stage. This includes the notices sent out by the board or the management company, as well as the pre-litigation notices and work done by a law firm or debt collection company. This is also the stage when a notice of lien would be filed to encumber the delinquent owner's property. Next comes litigation. This is when a lawsuit is filed seeking to collect the debt by getting the courts involved. Depending on the type of community, as well as the language in the governing documents, the type of relief that you'll be seeking could vary. So for some communities, they'll have the option to only seek a money judgment, whereas other communities will be empowered to seek to coordinate obtaining an order allowing for foreclosure. After a judgment is obtained, you're in the post-judgment collections phase, right? This is where if you've got a money judgment, you're going to look to try to garnish them. If you have an order allowing for foreclosure, you're going to be looking to coordinate the scheduling of the sale of the property. Finally, at any stage during the collections process, an owner may file a bankruptcy petition. If so, then the association will definitely want to have an attorney monitoring the bankruptcy action to best ensure their interests are represented in the bankruptcy case. Thank you for taking time to listen to our introduction to seeking to collect HOA and condominium assessments in Indiana. My name is Evan Conroy, an attorney with Conroy Law. I hope you all have a great day.